And our speakers this morning, I'll be introducing in a moment, but I guess every time we try to come up with topics, it's very helpful if you tell us what you're interested in learning about and hearing from us. So as always, we'll be leaving you with evaluation forms, please, to fill out. And at our last session, where we talked in particular about the July federal tax proposals, we had a number of people wanting to have a further discussion about it, and given the changes that have taken place since then, that's what I'll be talking about. But we also want to be responsive to non-tax matters that people have raised. And in particular, in a sense, it's another side of the small business environment, dilemmas that come up with shareholder agreements, how to prevent problems from festering and developing into disputes. And once there is a dispute, how to potentially mediate and even arbitrate and get in a confidential way a manner of resolving it. My partner, Peter Moffatt, will be talking about the shareholder agreements. Peter is one of our senior business lawyers, both in public and private client areas. John Campion, who's absent, but will be joining us shortly, senior litigator and mediator and arbitrator, will be talking about that topic. And we have a third presentation. It's in the materials by Soma Raelis, our employment lawyer, but unfortunately she had an accident on the weekend and is in bed and will be up and around in a few days, but right now, not able to attend. So our plan is to give you her presentation now, and next seminar, which will, let's see, we're in November now, probably be early in the new year, late January or February, we'll have her present hers at that time. John Campion is here. That's the program, and because we don't have the third speaker, you can come up, John, to the podium.
If it helps, I will do so.
Okay. Certainly will be open for questions and discussions during the course of our presentations, and we'll stay at the end, as we usually do, if people want to have questions put to us. So I'm going to be the first speaker, and the hot topic is usually pretty short, but I think it's going to be a little bit longer today because we're dealing with tax changes, that an update from what was proposed back in July. And you may recall, if you were here at our last session, I started my presentation, I was focusing on the passive investment income rules, transparency internationally, the automatic exchange of information, and the new proposals for limiting voluntary disclosure. I'm just going to focus on the first part of that in this presentation. But I think it's still important to have the context within which we're looking at the Canadian tax proposals. How do they fit in to North America with what's happening in the U.S.? How do they fit in internationally to what's happening? Well, right now we see in the U.S. Congress changes to their tax rules which could significantly change the tax rate arbitrage between our two countries. Typically today, if Americans are investing in Canada, I remind them that we have a tax rate in Ontario, let's say, of 26.5% versus in New York or California, the corporate rate could be as high as 40%. So it makes sense to leave the profits in Canada and reinvest it instead of trying to take it back from a low tax jurisdiction to a high tax jurisdiction. But if the Americans reduce their corporate tax to 20%, that changes the game entirely. From a personal tax point of view, there are also going to be reductions proposed by the President and both houses of Congress. Whether all of this gets implemented is a big question mark, but this is the direction they're going in. And so we're looking at a reduction in corporate and income tax south of the border, and in Canada, an increase in corporate and income taxes. Exactly the opposite to be competitive. And when we look around the world, we're seeing through initiatives by the OECD and the European community an attempt to try to get uniform taxation rules across the board. Rates may be different, but the attempt is to try to make sure that at least there is some tax paid where there are activities undertaken, so that profits don't go completely tax-free. And there's a lot of confusion in the reporting by journalists saying tax avoidance and tax evasion are the same thing. When the Panama Papers gets released, or most recently the Paradise Papers, anybody who has anything offshore is automatically tarred. That will eventually come out and be shown that obviously there are some people who are evading tax, but the vast majority are not doing anything illegal, but it's certainly not popular. So there's a lot of pressure on governments to, quote unquote, clamp down on what's perceived as improper tax avoidance. And now this is being translated this year into the taxation of small businesses. And keep in mind, there is a fundamental policy that's been in place for many years. Small businesses need help from the government. There's a barrier to entry. There's a barrier to remaining there. Costs, obligations, they range from employee obligations, the payroll, pension, the volatility of small business up and down. So 40 years ago, the government decided to give a low business tax rate, the small business deduction, to qualified active, Canadian-controlled active companies. And over the years, that policy has been tweaked, but never seriously questioned. And even in the most recent proposals that the government came up with, we're still maintaining the small business rate. And in fact, what the federal government announced as part of their changes in October and Ontario just last week is to feed the same problem, reduce the tax rate again, which will, low tax rate, which we'll touch on a little bit later. But it seems to me that the fundamental problem that they aren't addressing isn't the so-called avoidance or undue deferral, because there really isn't within a private corporation. It's the question of, is the small business deduction a legitimate tool, social and economic policy? If it is, then what's left all over in the company has to be left to be taxed the way it is today, not the way it's being proposed. That's my political speech. We'll talk a little bit about these different areas. The income sprinkling proposal is the first one. The second one I'm going to talk about is the lifetime capital gains exemption of today about $836,000 per person. The fourth one is the passive investment income rules. And lastly, the surplus stripping rules. So income sprinkling. Many of you are familiar today with the so-called kiddie tax, where if there is a business, a private corporation, or it could actually be a partnership as well, in which income is being earned but not being paid to the person who generated it, let's say the father or the mother who set up the company, but dividends, let's say, are being paid to minor children who are merely shareholders directly or through a family trust, then the tax rate goes right up to the top. And that kiddie tax is put in there as a means of preventing what's viewed as undue income sprinkling of wealthy families using a corporation as a vehicle. The July 17 proposals would have increased the scope of the kiddie tax to make it a family tax, in effect. Any child, whether adult or a minor, a spouse, a nephew, niece, all of the parties who are related persons who get income, directly or indirectly, would be hit with the highest rate of tax. There was going to be a test that would apply to a band of age between 18 and 24, assuming that these men and women were in university and not reasonably possible for them to participate in the business. Then there was going to be a very strict test, and other members of the family, difficult but not as strict. A lot of complaints, discrimination, unfair, difficult to administer, and so the government has backed off. And the rules now will say that all of the people in this class above the age of majority will be asked to demonstrate how they've contributed to the corporation. And here are the factors that will be put in the legislation. What labor was put in, what capital or equity contributions were put into the business, what risks were assumed, and what catch-up of past contributions were put in, or past assumptions of capital or risk. So all of the tests now are going to be uniform, and it's still a very strict regime, but not as discriminatory. And we're expecting that it'll be effective for the 2008 taxation year, with the details to come out in the next budget. The lifetime capital gains exemption. This is something that in our typical estate planning is a tool that's really been at the forefront of what clients are interested in. When we talk about an operating company owned today by the entrepreneur, and we do an estate freeze, let's say a share-for-share exchange, fixing the value of the shares that are taken back by the entrepreneur, we can actually trigger a capital gain if the shares at that time qualify, and that person can bump the adjusted cost base up to the $800,000 plus. But then we want to bring in a trust, usually, for the family members who are going to participate in the common shares as they grow. And if the business is sold, the entrepreneur sells the frozen shares to the purchaser, and the trust sells the common shares, which have grown in value. And if the shares at that time are qualified small business corporation shares, then we can pass through the capital gain that's realized by the trust to members of the discretionary class of beneficiaries and multiply the capital gains exemption. I did a reorganization a number of years ago for a capital markets firm that was expecting eventually to either go public or sell, and each family had a capital corporation. They were in partnership with the other members of the firm, and we set up a trust for family members. One family had 5 children, so when they sold, they really had a home run, multiplying the capital gains exemption by the entrepreneur and the 5 children. So that way you were sheltering $800,000 times $4 million of capital gains. The government initially in July viewed that as excessive on the theory that why should a trust be used as a vehicle to enable non-active members of the family to get a capital gains exemption. When it comes to income sprinkling, they were saying you have to show contributions, so they were initially proposing that when you claim the exemption, you've got to show contributions. And they were tainting the whole use of the trust, which is, in a sense, typical of a lot of these rules, shotgun approach, without carefully thinking about the implications. But there were so many complaints that they did back off. And so the government is not going to limit the claims to the capital gains exemption. They'll still be available for that multiplication through the trust. Now we come to the passive, it's so-called dead money, the passive income of a private corporation. And I won't go into an attack against the purveyor of that nomenclature, and some people accuse of hypocrisy. We won't have to get into that. We'll just say that we want, ideally, our leaders to be models of consistency, and maybe that's not the case today when it comes to their own personal affairs, when they're attacking people who are also successful. Right now, I'll remind you how it works with a small business, claiming a small business corporation, claiming the small business deduction. Let's say it's a 15% tax rate, roughly, leaving 85 cents on the dollar for reinvestment. In the government's policy papers in July, what they said was, that's unfair. Not the small business tax rate, but the 85 cents on the dollar is unfair because a salaried employee taxed in Ontario at 53% is left with 47 cents on the dollar. And they compared these two and said there is no horizontal equity, whereas apples and oranges aren't the same. They have come to recognize, after 20,000 submissions came from across Canada, which is unheard of for a tax proposal. And it was from many different sectors of society, not just the ultra-wealthy, but doctors, lawyers, dentists, ordinary entrepreneurs, and particularly farmers and fishermen. They always have a voice well beyond their numbers in Ottawa. And so the government was persuaded that it was overkill to say that the current system, which deals with how income on that 85 cents is taxed, is unfair. Because what happens today is, let's say there's 10% earned on the 85 cents, the 8.5 cents of income is subject to 50% tax. There's no deferral. It's roughly the same as an individual. The difference is there's a refundable mechanism built in so that we have so-called integration. When that corporation pays a dividend, a taxable dividend, out to the shareholder, the corporation gets a refund, the individual pays tax with a dividend tax credit, but overall the corporation and the individual are taxed at roughly 53% at the top. So corporation has no deferral because it's 50%, and when the individual gets the tax, there's no undue tax reduction. That is today's reality, but the way it was portrayed in the government papers was that doctors and business people are getting an undue deferral by the use of this corporation and the dead money that it earns. There isn't any deferral. They still have not quite gotten over the ideology, because this is what it really is in my view. It's not good economics, it's not good tax policy, but it's more of a belief. And the proposal would be this. If the private corporation has $50,000 of passive income, typically they're saying, let's say you have $1 million of surplus and at 5% it earns $50,000, that is a threshold below which we will keep the current system going. You'll be able to get a refund and it will be integrated. But if you have $2 million and you're earning an extra $50,000, that will not be eligible for the refund of corporate tax when the dividend is paid out. So what are the implications of that? Double taxation. And a total of 73% when you combine the corporate tax, fully distributed dividend in the individual's hands. And the rationale that the government came out with was they did a very broad survey of large corporations, and it's a very small number, like maybe less than 5% of all of the small business corporations in Canada would be subject to the 73% tax. So it's not so bad. That was the rationale. That makes no sense in terms of equity or economic policy. If it's bad policy, it doesn't matter if it's just hitting a small group at the top. It's bad policy. A lot of the complaints also came from the venture capital industry because they were looking at business people as sources for venture capital. And if there's this draconian tax that is imposed on small businesses with respect to the surplus, they don't want to just put it in GICs, let's say, they want to put it to work in a startup company, that could be viewed as dead money or passive income, and very with a very negative implication for innovation, and our Liberal government wants to push for that. So in their latest announcement, I've got on the screen what they are saying they're going to do is to look at ways of maybe carving out capital gains from that draconian set of rules so that people will be able to invest their after-tax surplus in growth companies and not be subject to the additional tax. We'll see if they actually come out with that, but at least there's a possibility. And they say they're committed to look at this, but they are still wanting to go after high-income individuals as the focus. But coming back to what I suggested earlier is really the fundamental question is the small business deduction and a low business tax rate justifiable? In my view, maybe what we should be doing is the same as countries like the UK, all corporations tax at the same reduced rate. Then there's no problem with dead money and so on. So instead of addressing that as a problem, what the government has done is come in to bribe us with our own money and say they're going to reduce, both federal and provincial, reduce the low tax rate from the current 15% to 13.5% next year in 2018, then to 12.5% in 2019. So what's the result of that? If we've got today 85 cents on the dollar that's dead money, we're just bumping it up. We're going to have 87.5 cents on the dollar, causing problems. So there's no logic to what they're doing. It's all politically driven, and it's unfortunate tax policy. The final item that was very controversial in the July proposals, converting income into capital gains. We had an existing rule that was going to be expanded and a new rule that was going to be brought in. And both would say, if you've got a private corporation that on distribution of the profits could have been done in a tax efficient way through, let's say, a capital gain, and it might be an individual transferring assets on a rollover basis to a private corporation, taking back consideration. If it's only shares, that's okay, but if you take back non-share consideration, such as cash or debt, under Section 84.1 that I point out on the slide, that could trigger a deemed dividend to the person who's related, who's the transferor related to the transferring corporation. They were going to expand that, and they were going to have a broad anti-surplus stripping rule in proposed 246.1, which would have really harmed a lot of our post-mortem tax planning, the so-called pipeline transaction, which was viewed as quite legitimate by the tax administration. In fact, the CRA published numerous interpretations and permission to do this kind of transaction. Typically, an entrepreneur owning shares in a private corporation dies, is deemed to dispose of the shares at fair market value. A capital gain is realized, tax is paid at the level of the deceased in the terminal return. But there are significant assets in the corporation. And there could be double taxation if those are distributed out to estate afterwards. So what we've been able to do up until July would be to set up a new corporation by the executors at the top, and to have the executors take the deemed disposed of shares from the estate, transfer them into the new corporation, take back notes or shares at fair market value, because the capital gain bumped the shares of the deceased. And then keep that, maybe amalgamate the two companies, keep that company in place for a year, and then pay out either by way of a redemption of the note or of the shares to avoid a dividend. So we have a single layer of tax at that level. That was the capital gains tax, but we don't have the second layer, which is the distribution tax. The government is going to block that by saying that is a surplus strip. What you are doing is improper, because you should be paying tax on any kind of distribution and not allowed to, in effect, convert that dividend into a capital gain. In particular, the farmers were up in arms about this kind of blockage of intergenerational transfer of assets with double or even potentially triple taxation. So they did back off entirely these proposals, fortunately. So 84.1 stays as it is, and 246.1 is not going to be enacted. So the pipeline transaction is still good, and they are dropping that entirely. So in summary, what we've seen is that in certain areas, the government has responded to unprecedented complaints across Canada. The lifetime capital gains exemption can still be multiplied. The surplus stripping rules are gone, but we have to be very careful with income sprinkling to members of the family who would have to demonstrate some reasonable contribution to be able to get either dividends, or even salary has to be reasonable, and so on. And I'm expecting there'll be probably further changes to the passive income rules, because they're still, in my view, seriously problematic, and people are still complaining about them. They just don't work, and they're just bad policy. So that completes my presentation, and I'm going to turn this over to John. John's going to talk to us about shareholder and business disputes. Let's see. Yes, thank you very much.
Good morning. I am going to indeed talk about disputes, but I'm also going to talk about sexuality in the workplace and abuse, because my friend Soma has been apparently hit by a woman and is injured at home. Someone fell on top of her, as it turns out. But I want to take a bit of a broader view, because I think that we are in an age of revolutions. Every age of people think that we're in radical change, which is what I characterize as revolutions. But the revolutions that we are involved in are unique in one way only, and that is the speed of disruption. Disruption, in my view, is something which occurs around the world and in a lifetime. That's the kind of disruption that is hugely revolutionary. In short, there's very little time to adjust, and there's certainly no time or little time to educate people in the next generation about what has just happened to them. And in the revolutionary world, in my view, feminism, I think, stands out as the biggest revolution that we are facing. And we're seeing consequences of revolution in Soma's talk, which I will deal with up front. The second revolution that is important and highly disruptive, which affects our lives, which I will deal with in part, is technology. It was predicted that the computer chip, would increase in power every 2 years by doubling. This was 1957. As it turns out, we surpassed that. And the implication is that if you took a 1970 Volkswagen and you applied the same technology to it that you applied to the computer, the car would fly, it would last more than a lifetime, and would only go on a single tank of gas. So when you think about what's happened, and it's increasing in speed, so the disruptive power will affect our lifetime, regardless of how old any person is in this room. You will see the changes. By that, it will mean all of humanity will change, or have to change, and have the focus. The other two are globalization and climate change. And globalization is possibly driven by technology. It's not the first time in history that we've had globalization. The Chinese had it in their world. The British had it up to 1914 when Europe decided to commit a collective suicide. And what will be seen as three wars all in one, namely First, Second, and the Cold War. All that will just be seen, in my view, as the Europeans failing to get around their tribal nature and deciding to blow themselves up and the world and lose power in the same phase. And so globalization is a complex one because we've seen the benefits in free trade, but we've seen the detriments with Brexit and Mr. Trump, where there's been a huge reaction because we left too many people behind. And that's the power of disruption. With too many people left behind, there's going to be a reaction, and the reactions may be positive, they may be negative, depending on your point of view, I suppose, on Mr. Trump and Brexit. And the final thing is climate change, which is one of those off-the-cliff experiences. I just was reading on Sunday in the New York Times about a family who lived in what effectively is the desert, but because they're at the toe of a glacier, they've had very, very productive lands in Peru. Well, those productive lands are now done. The glaciers are gone, and they're not returning anytime soon, as far as we know. So climate change is one of those huge moral issues that can hardly wrap your mind around. So within this context, we all feel, I'm sure, a sense of disquiet. It is, you know, the old expectations that we grew up with are now being challenged at every level. And those challenges are oftentimes terrific. And I'm going to then turn to Soma's speech on, you have to give me a sense of how long I've got to, how long have I actually got? Thank you. So let me turn to Soma's, and can I have Soma's slides, wherever who's in charge of the slides? So I want the second set, if you don't mind, but I'll deal with them. So the feminist revolution is by far the most important revolution because it involves half of man and womankind, personkind. And it is, I suppose one can say, European and North American focused, but even the Saudi Arabians are getting around to letting women drive, and as we know, once that happens, who knows? Once you gave a car to a 16-year-old, they were gone with the wind, and so the car turned out to be a huge revolutionary tool. And similarly, so in other places in the world, that feminist revolution has taken hold. Now, in a revolution, heads are lost, sometimes legitimately, and sometimes not. As you may remember, Dr. Guillotine made the weapon, or made the guillotine, because he was so concerned that the axeman, during the time before his invention, kept missing, and the results were terrible. So he created this as an instrument of good, not an instrument of terror. But of course, heads were lost in any event. Napoleon, by the way, in the feminist revolution, and we've seen bits and pieces of it leading up to that point in time, he used the support of women to deal with his revolution. But as soon as he came to power, he disallowed more than 2 women to meet on the street or in public, because he didn't want to have the feminist revolution. In short, he stopped it cold by making it a law that women were not allowed to meet in public. So the feminist revolution has had a pretty difficult run until now, certainly in North America. And now we are seeing the rightful women taking their rightful place. In my year in law school, we had 1/3 women. Well, that was the first class that had it. And law, I will say, has been relatively good at absorbing women. Not when you read the most recent article in the Globe and Mail by a young woman who was at Baskin's, who wrote about her discomfort, a black woman. It wasn't actually a wholly negative thing, because she was invited into the partnership. She was there, but she just found it uncomfortable and difficult. Oddly enough, every person I've talked to who's read it, particularly young people, men and women, really like this article. There is a disquiet in the system. So let me deal with, there we go, those please, yes. And if you can give me a button that allows me to turn it, I'll turn it from here. Okay, thank you. So let me deal with the revolution as I see it in okay. Thank you. So we all know of Mr. Weinstein. He's an abuser. I mean, if it was one of my girls, I don't know what I would think, but it wouldn't be very pleasant. I can assure you as to what I think the consequences should be for this man. He's just an outright criminal. But it is a movement. And when you look at the senior people who had to move on, you can see that it is men who are very powerful, who are sometimes political, and they are accusations. One of the difficulties in all of this is that it may be that some of the accusations are not true. It doesn't matter. We are in a revolution, and revolutions take heads. There is no room for, oh, I was caught in a changed set of expectations. It doesn't exist. That excuse is done. And mainly because what John Willis, a professor at the University of Toronto, who's now passed away, he was a brilliant fellow, he spoke about, and I translated it to be, publicity as a sanction. Now, in this day and age, we know publicity is a sanction, but in those days, when you didn't have as much easy reference to the public, it wasn't as powerful. Although you got charged criminally, you were pretty well done. In small town Canada, Canada was everywhere a small town when I started out. Now, publicity as a sanction is worldwide, and it doesn't really matter what your answer is. You're done. It may be entirely unfair, and I'll deal with the unfairness in a moment, but so be it. The revolution is tough. And so we have to adjust to it, and I'm going to deal with a bit about the law. I'm going to touch upon not just consequences to men. I suppose it could happen to women, but it hasn't been, but it certainly has happened with people and young people. One of the new pieces, for those of you who are lawyers out there, is, and I mean in-house lawyers as well, how far can you protect somebody? David Boies, one of the leading barristers in the United States, acted for Mr. Weinstein and the New York Times and a number of other companies because he is such a prominent man. And he protected Harvey Weinstein by paying off women and getting them to sign documents to say that they wouldn't sign. And of course, he was, just like the Catholic Church in Ireland, they were enabling the conduct by hiding it. And so David Boies is now he got fired by the New York Times, and publicity as a sanction is huge. Now, he happens to be 74, 75 years of age, still a very senior man, and to some extent, his career at least has been blotted. So you, who are lawyers, who fail to act in accordance with the law of Ontario, are going to yourselves be judged. That means telling the CEO that he's gone, or she's gone, and for misconduct. That's a new world for us. Solicitor-client privilege isn't helping David Boies. Now, he was doing it in public, and the women signed the document, so fine, but it isn't going to save anybody. We are in the midst of a revolution, and we've got to all adjust. And I want to talk about one of the sadder ones is George Bush Sr. for putting his arm around women when he's sitting in a wheelchair and pictures are being taken. Now, one would think that's gone a little too far, but revolutions take heads. And oddly enough, it is despoiling for him, albeit on the minor end of the scale. And in one view, you'd say, really, can that be possible? But look at these other people. Their political careers and their careers are being really badly hurt. So to give you an idea, and so the revolution can be seen to be North American and situational, but I don't think so, because the feminist revolution began in my modern lifetime, at least as far as I see, in 1962. At that point in time, the pill was created, and women were then free to choose the time of when they would have, or whether they would have children. And that is the turning point in the revolution, when all of a sudden they could participate in the workplace in an organized way. And just because, well, I remember my grandfather, my aunt was the brightest student that had ever graduated from the high school in Bracebridge, Ontario. And my grandfather was a farmer and had a lumber business where he had 16 employees and he had a number of children. And this is now we're dealing with in the sort of 1910s, sort of 19 teens. And the principal came and asked my grandfather at Central University. And he said, absolutely no. One person went, my uncle went, and he was the only one. He was in school with John Kenneth Galbraith at the Agricultural College. But the women, no. She went on to have two boys. One was a nuclear scientist, and the other was a very famous doctor. But she wasn't allowed to go. So the changes have occurred now from that raw attitude, but only in 100 years ago, certainly in my mother's lifetime. So the Me Tooism is an indication where people who have been abused are standing up. By the way, if you ever go to a Catholic church in Ireland, you'll see there aren't many people in the church, because the Catholic Church in Ireland, because of the way in which pedophiles were allowed into the church and remained unpunished, was devastating to the church in Ireland. It is finished as an institution in Ireland. It's not just dislike, it's hate. It's not just ignoring it. It is raw power. You talk to a taxi cab driver, you cannot talk about the Catholic Church and where it has been in Ireland. Well, those are the kinds of reactions that people are now having with regard to the role of women in society. And it's mixed, it's a complex thing for us, because of course, we all grow up, we all see every day sexuality being used for advertising, or you can see it on computers. An 8-year-old boy or child can see it anywhere they want. Just because they don't see it on your own computer, they can certainly see it someplace else. So the world is complicated, but we've got to adjust. If we don't, the consequences are the end of your career, and the end of your president, and the end of your company, in the rare case with Mr. Weinstein. So there are serious consequences of this. 4.7 million people and 12 million posts in the first 24 hours said Me Too. That's a huge reaction, and on it goes. So, question of power, abuse. Here's what Lorne O'Connor had to say about it. Balance of power is 0 for me, and Harvey Weinstein is 10. It's a complicated matter, but I won't bother going into the cost of bad behavior. But when you look at the rogues gallery of people, this is real cost in terms of money, but the real cost, in my view, is the reputational impact. You just won't ever be able to live out the rest of your life in any meaningful way at all, socially or otherwise, and rightly so. But the money is spectacular that these men were paying to carry on their, and by the way, that's one that people don't get at night. And there is that whole underlying thing. You know, Mr. Trump dealt with his own conduct and just said, oh, well, it's just locker room conduct, locker room conversation. Well, can you believe the President of the United States could be elected after that commentary? Is it even remotely possible in our lifetime this can happen? So we have a big problem. There's lots of resistance, and the resistance begins every single time a new child is born, because we have to begin all over again. Sexuality is such a huge single part of our life. George Senior I've dealt with. So let me deal with the human rights legislation. And you all know this, but just in case you want any reminder, every person who's an employee has a right to freedom from harassment in the workplace because of sex, sexual orientation, etc. Every person has right to be free from sexual solicitation with the promise of something else, or reprisal for rejection of sexual solicitation. Those are commonplace understandings, but it's good to remind ourselves that they exist. And again, I come down to in-house counsel. This is a big deal. If you don't deal with somebody who's the president, who's been involved in something like this, or a board of director, or name it, you yourself will be on the line. In the occupational health and safety, you've got responsibilities for workplace policies and making sure that they are reviewable. And if you think it doesn't happen in Canada, 43% of women, Canadian women, and 12% of Canadian men have experienced sexual harassment at work. That's a huge number, no matter which way you cut it. Plainly, the message is slowly coming out, and there we go. So that's as much time that I want to spend on the sexual harassment piece. The rest of the issues that SOMA leads deals with are the modern implications in cost in Canadian experience. And they are very compelling. And the last point is the one that still I remain, and that is, what are the limits for counsel? Do you have a conflict of interest when your president's involved? What are the rules of professional conduct in our profession? You can't subvert the law. What can you have somebody sign to keep it quiet? All of those things are yet to be finally determined. So let me then turn away from the sexual conduct part of the SOMAS to the revolution that I believe is happening in the economy, where every 5 years we are going to see disruptive change. And the pivot point for this one isn't 1962, where I would have the pivot point for the modern women's movement in the workplace. But the pivot point is 2007. And that's the coming of the iPhone. And the iPhone was unusual because it had these things called apps. And these apps are this extraordinary mathematical formula that underlies every single activity on an app. And there was a point when I started law that we were high priests. The chairman of the bank would call, you'd go in and see him, he'd give you, in this case it was him, they'd give you a problem, you'd go away, and 5 years later you'd come back with some solution, having been to the Supreme Court of Canada or not. You might talk to the in-house counsel, but it was unlikely. You certainly might report to them. The chairman wanted to know. I remember when Walter Williston sent the largest bill ever sent out of the law firm. It was always done at the end of the case. It was sent to Imperial Esso for a win that they'd had in a very important case, and he sent the bill as $100,000. Imperial Esso refused to take that bill and sent $300,000. Now, that's not happening so much these days. The high priest's role has been diminished. But what is this high priest role, and how does it work out? The new high priest is the algorithm. It's the thing that nobody understands. Look at Bitcoin. My son was telling me about how Bitcoin got created by a Japanese mathematician. And it is still somewhat mysterious. Not people understand the results and some of the results, and they're getting their minds around it, but I certainly don't have a remote clue really what it is. I've tried, but it's not working for me yet. And so the only mystery left now isn't religion, it isn't professions, it isn't respect. It comes even to judges, although they seem to be hanging on a little bit. Certainly isn't to corporations and heads of corporations. It's to the algorithm. And with that comes this unknown piece and speed. Speed of change is hugely disruptive. So, dispute resolution. If I could get my own little slides up there, that would be helpful. Thank you. Just so I can flip through it. So, dispute resolution, there's litigation, there's arbitration, there's mediation, and there's settlement. And settlement can be with professionals or just make the deal yourself. Now, you would say that if you wanted to get to an end, you would almost invariably do it yourself. Because the cost of retaining counsel, the cost of waiting 5 years is huge, or 10 years, as the case may be in some of the cases I've been involved in. And you wouldn't do it that way. Sometimes the costs are larger than the thing in the first place. But dispute resolution isn't a matter of getting to an end for lots of people. Sometimes people want delay. Sometimes CEOs are just as happy the thing gets settled sometime after his or her regime. And on it goes. There's a million psychological reasons. I love the person who says, I'm going all the way to the Supreme Court of Canada. Bring it on. It's terrific. But they're few and far between, and seldom do they hold on to that over the time that it takes to get there. So what I want people to focus on is that litigation and arbitration are identical. One's a command of Her Majesty to appear in your courts, and you have a whole lot of problems, a whole lot of issues attached to it. Arbitration is more or less the same. It's by consent, but you still come to the same thing, and you have some form of documentary discovery, some form of pleading, some form of exchange of information before the hearing, and then you have the hearing. They're more or less identical. And depending on the circumstances, arbitration can even be more expensive, but at least you can control some extent the timing, and certainly control the process. You don't have to do it in public, it's confidential. So there are other pieces, but they're largely the same. Mediation, there's two kinds. There's the kind that Harvard would indicate, and there's my kind. The Harvard would say you want to love them into a settlement. So you find ways to make interesting compromises where everybody walks out satisfied. Well, and I took that program and enjoyed it immensely, but I was in Ontario. I don't actually believe you can do it that way, and if you get it done, that's fantastic. It's the best of all worlds. But my view is that mediation demands at some point, because of the different bargaining power of individuals and stuck in the mud circumstances that people have about their disputes, you need someone who can tell them some of the tools as to how things are going to actually look at the end of this and drive them to a solution, knowing from your own perspective that it's the right way to do it. Now, that's how I see it mainly. It isn't the most preferred way, because people don't always come out feeling good about themselves, and they sometimes feel like they're equally unhappy, which is always a good place, or equally happy. The equally happy kind takes forever and is largely not going to be successful. The hard-driving one is good. So what are the tools in the hard-driving one? The hard-driving one, first of all, is the barrister's mind, or the barrister's perspective. And let me just take you to, where's this? There we go. So, how long have I got left? 10 minutes, thank you. So this is a quick tour. Everything you need to know in law is analysis, process, and strategy. If you get those words and you understand them, I'll give you a law degree. There's nothing to it. It's very simple. And the trouble with the lawyers and the high priest role is that they weren't into simplifying. They were into complicating. But it's very simple. Analysis, process, and strategy, that's all you need to know. So what's analysis? Analysis this is the lawyer's training. What is the cause of action? What's the legal box in which I'm putting it? Is it breach of contract? Is it negligence, which is a tort? Is it restitution? So you've wrongfully taken something, you got to give it back. Or is it dealing with some kind of property, intellectual property, real property, or trusts, or something like that? There are 4 categories of things. So analysis is if you're putting something into a court or into an arbitration or into a settlement, what's the box in which you're putting it? And in the Harvard bit of arbitration, they would say, well, the box isn't important. You look at somebody's interests. Well, I don't disregard the interests, but you're not going to escape the box, because when you run into somebody who's really tough, I'm going to look straight in the eye and say, this is how it's going to turn out. I've been running the system and in the system for now 45, almost 50 years. I've been studying and acting and practicing law. Well, I can tell you what's going to happen. I know what's going to happen. I've seen your problem 1,000 times. There's no problem I haven't seen. That doesn't mean I won't be creative, but I've seen it before. And I know how it's going to turn out. And it's going to be ugly to go and fight the whole thing all the way. And people will be largely dissatisfied because of the cost. So I can tell you what's happened. Well, that's putting that thing in a box. And that's a powerful tool to tell somebody who's being recalcitrant, this is what's going to happen. Or then, of course, what's going to happen to your damage claim. So there's 2 pieces in this analysis point. How's this going to look like in damages? What's your expert going to do? How's they going to survive? Well, I can pretty well tell you how it's going to happen. It doesn't always work. But that's the legal mind, which is a tool, and a major tool in moving people from where they are, angry, upset, hurt, frightened, looking for time delay, or whatever it might be, to some other place. Process. People think that process is the litigation process or the arbitration process, and that's what process talks about. Well, in one big case, I brought in a multi-billion-dollar obligation to build nuclear units. I brought a summary judgment motion at short notice with materials that went from here down to the floor. And I can still remember Tom Heinzman turning purple before Justice Lane. He was so mad at me because I brought it on short notice for a motion for summary judgment to compel the government of Canada to build 2 reactors. Well, it was great fun, I will say. I didn't get the order that day, but it sure focused attention. And what I did the next day was, I picked up the telephone, I called the leader of the opposition's office, I said, put a question to the Prime Minister on this issue. He did. And guess what? In a very short time, we settled it. So process isn't just fighting in litigation, which I did day 1, although I must have been prepared for a fair time to get to day 1, but it was going to the department. Criminal law, if you make a complaint to somebody, that's a process. You go and complain to the police. By the way, you only have one arrow in that quiver, because if you go and complain, then it's all done, because you lose control. And you may not want to lose control. And by the way, if it's criminal, you don't have any insurance. So if you're claiming that against your lawyer, it's not a really good idea. And then there's complaints to the Law Society, to the Nurses Society, to the Medical Doctors Association. There's all kinds of processes that you can do. Now you can just go on Twitter. That's a process. And it's a legal process. You may get sued for it, but it's a process. So process is a huge extra piece. And when I go to talk about where the people are going to settle, disputes or not, I'm going to talk about process and where it's going to go and where it might not go and how ugly it's going to look if you're found not to be telling the truth in the judgment of one of our judges. Our judges are largely untouched right now. If someone says you're a liar, you're done in a court case. Then you've got strategy. Well, strategy is everything you could ever think about in human conduct from the beginning of time to now. And by the way, we've only had 5,000 years of written material. There's no reason why we shouldn't have read everything. We've only had 5,000 years in writing. Mankind has been around the super brain for about 195, or longer than 195,000 years ago. But they escaped from the Serengeti about 195,000 years ago. All of us, one small group, that's where we all came from, 195,000 years ago. Hope there's not a biblical question about this one. But we have 13.8 billion years of the planet, 195,000 years of Homo sapiens with their super brains running around the earth and populating it and becoming dominant. And we have 5,000 years only of writing. So there's no reason why you don't know about it. That's where strategy lies. It's a strategy about psychology. It's about passion. It's about words. It's about, I'm upset. People, when they get fired, they always say, it wasn't that I got fired, it's the way in which they did it. Well, give me a break. It's not the way they did. Nobody can get fired in a nice way. You're done, you're done. It's the fact that you're hurt. That's all. You're just hurt for being fired. So once people get over that, and they're told, don't worry about how, then they lose their anger, and they say, all right, it's all about money, and away we go. It's done. It gets done very quickly. So psychology and strategy, publicity. So if I sue a company for $100 million, they're going to be reporting on their financial statements. And they're going to have to go to the Securities Commission. It's a public company. Well, that's a form of strategy. If I sue all the directors, I'm going to have every single one of those directors represented possibly separately. As in Xerox, where we had about any number of people, and I had to hold this crowd together, whereas Xerox got sued when it was a public company in Canada. But all of a sudden, if I'm the plaintiff, I've got 10 lawyers on the other side. You ever try to get 10 lawyers to get through a case, through discoveries? It's forever. So that's a strategy. You may want it, you may not. Can you pay for it, or can you not? So analysis, process, and strategy is what I think about, are the set of tools that come into when I go to negotiate. And let me quickly, oops, there's the wrong way. So there is all the sources of law. Let's take you through it, no time. There is a better set of explanations. Every single one of those little dots on principles is a story. We have good time. So this is litigation process. There's only one point that matters. You stand on your feet with all the law and all the facts, and you argue it. That's the point you're aiming for. By the way, almost nobody gets there anymore, because the kids who are doing the examinations for discovery think that's the process. They spend all their time and money doing it. And guess what? They exhaust the revenues, they exhaust the parties, and everybody settles. Well, that's not good anymore. 7 years, are you kidding me? Do you know how many times you go through a set of documents to go from the beginning of a case to trial? 7 times at least. 7 different times you go through this document set. You have to do it when you meet the person, you have to do it when you do the pleading, you have to do it when you prepare for documents, you have to do it when you do the examinations for discovery, then you have further questions and motions, and finally you get to trial and you go through it again. Who can design a process like that? Well, I know who designed it. It was Walter Willis who designed it when I was one of his juniors. But that was the age looking backwards for perfection. He put in all these systems in order to get the tricks that he used to pull on all his friends. And so all of a sudden now, it's no good to us. We don't have the time. We don't have the resources. So what are you going to do about it? There's got to be a faster way. There are lots of ways to do it, but I can't get my paws on the civil system. So then this is a little more complicated. This is class actions. This was done for the Brioche case. You may remember an $8 billion case where I was acting for VMO. We won the motion for the case, believe it or not. We wouldn't win it today, but we won it then. And this was, I was charged both the Americas and Canada. For this one, I appeared in Texarkana, which is a courthouse built on the borders of Texas and Arkansas. And when you go to the courthouse, you go to the Texas side, you take your gun, you check it in on that one side, you go to the courtroom, you argue your case, you come back out, you want to argue something in Arkansas, you get your gun from Texas, you go into Texas, you go just across the hall, and just take the gun, check it in on the other side, and away you want to argue in Arkansas. That's how the courthouse works. And if you sing the song "Old Cotton Fields at Home," you'll hear Texarkana. It's a cotton town. And anyway, that was class actions. It's a little more, process can get complicated. Arbitration, it's the global process. One single statute, the most important statute or treaty that's ever been done was done in 1956 with the United Nations of the reciprocal enforcement adjustments. You think, well, what does that matter? Well, if I have an arbitration, 195 countries have signed on. If I have an arbitration, it's enforceable. So I have an arbitration in Nigeria, and I don't trust the court system. I'll say I wouldn't trust the court system in Nigeria, but if that were the case, I can enforce an arbitration. I can choose my arbitrators, and I can enforce it, even though it's done in Nigerian law. No matter where it takes place, I can enforce it in Nigeria, even though that whole arbitration took place in New York. That treaty would what allowed that to happen. All of a sudden, global business could invest in countries where they didn't know or didn't trust the system or didn't like the language or didn't like whatever they were worried about in terms of corruption or otherwise, and they could enforce it, therefore they could go there and invest. And that led to huge globalization and the globalization of disputes. Then you've got, I wish I could take more time, but we don't, mediation. So you've heard me a bit on mediation. It isn't just a passive process, and nor should you be giving it into the hands of people who tend to be passive. That might be the proper case for a human rights case where you need to sort of make people feel bitter about themselves in a terrible situation. But in raw business, you want somebody that's tough. You want somebody who drives. And I've heard more and more people say, look, I'm just so sick and tired of going to a mediation. And then when you walk out, people just sort of say, well, this is the result. Okay, if you're coming to me, it's going to be settled one way or another. I'll get you halfway there, nothing else. I'll get you down to a single issue, define it, and say, fine, go off and have somebody else decide it. Or I'll decide it. We'll go and change it from mediation to arbitration. So you can get to an end with a whole lot less trouble and still have the satisfaction of going to war. There's really something very good about purifying about going to war. So mediation can be used not just for limited purposes of getting to an end, but to get to a point where much of the, and I'd love to take you through a couple that I've used where I've hired people, separate people to do documents. I've hired separate people to give me numbers for the damages. So, and it'll be binding. So I'll give it to an accountant. They take all the information, all the experts, and they come up with a number. Not the result, but with the number. So you don't have to spend 5 weeks in court analyzing what 2 accounting witnesses have said. All that has a possibility. Just choose one person, they give me the number, and I went on from there. So the mediation process can be lively, can be passionate, and can get things done that nothing else can do, including I can take you up for your one issue at trial or whatever it might be. Then process, there we go, all the places you can go and have processes. I've dealt with that. Then psychology. My view is litigation, arbitration, mediation, settlement, they're all the same. You start out with the lawyer's box. You get the fact. And by the way, the best thing that you can find in a barrister is somebody who can take a negative fact and turn it into a positive. I learned and saw Dudley Law, McCarthy's sadly passed away, was a magnificent man at taking a bad fact and making it a good fact. Just base it right down. And it's fantastic where he can be creative and turn it around. That single capacity in the lawyer's toolbox is a spectacular benefit. And you can surprise people like nothing else. Creativity is fundamentally important in dispute resolution. Psychology, therefore, litigation, arbitration, mediation, they're all the same. The lawyer's box, the psychology, the speed, the cost, all those things work together for all of them. Doesn't matter where you are. You're still going to have all those pieces that I've talked about. And then finally, the inside and outside factors, I've dealt with some of those, and you're now all lawyers. It didn't start out that way. Thanks very much.
Thank you, Ben. Peter Moffatt is our last speaker. Talk about shareholder.
Morning. I have the enviable position of following my esteemed colleagues and dealing with a subject that can be quite dry, but does generate a lot of interesting situations and perhaps some passionate debates and dispute resolutions at the end of the day, as John talked about. I'm going to jump around a little bit on this topic, and I want everybody to feel free to jump in and ask any questions they would like to have answered on this. There are a number of ways to go on this presentation. There are a number of factors to discuss. As you'll see in the materials, I've suggested there are a number of, I've suggested a couple of contexts in which this is relevant, and those contexts present a different set of variables that have to be addressed in a shareholders agreement, such as a closely held business that a family owns, that's dealing with succession issues. You've got shareholders agreements in the context of venture capital, so early to late stage growth business, which is taking in new money, and there are all sorts of complications that have to be dealt with in that context. As well, you can have shareholders agreements or variations of shareholders agreements put in place with respect to foreign entities doing business in Canada, and even if it's a wholly owned subsidiary here, there are certain issues that you want to deal with from a shareholder/director level that you can employ a shareholders agreement to deal with. So as I said, I'm going to jump around a little bit, and please feel free to interject and take us off on whatever tangent would be of interest to you. I'm very open to doing it that way, as opposed to just boring you with the obligatory, what is a shareholders agreement, what is a unanimous shareholders agreement type of commentary. So, general overview, I think that it's important to note that the way I thought of dealing with this is again subject to you interjecting and making this more interesting with some real world suggestions and or questions that we'll go over, again, the obligatory, what is a shareholders agreement, identifying the difference between a shareholders agreement and a unanimous shareholders agreement, which is somewhat creature of statute. Then dealing with the common elements in the shareholders agreement. Now this is a very long list of common elements, and whether something's a common element or not will depend on the context that it's being employed. So we'll deal with the context as well, and maybe after dealing with the common elements, then take those different boxes and put them in place where it's relevant in the various contexts that I have alluded to earlier. So then we'll move on to the common elements. So, well, let's do the obligatory, what is a shareholders agreement first? How about that? So in its most basic form, it's an agreement between two or more shareholders of a corporation to govern what the corporation can and can't do. Now, together with the articles of a corporation and its bylaws and the relevant corporate statute, to the extent you're not contracting out of said statute with the provisions of your shareholders agreement, set the baseline governance parameters for a corporation. Now I say baseline because a corporation will then further perhaps put in place, depending on the industry they're in, or in some cases, cross-industry policies and procedures that they are governed by. If you're a securities dealer, you have to have certain policies and procedures in place. Most, if not all, businesses have to have some kind of privacy compliance policy in place. So that will further dictate the governance of a corporation. But at its most basic level, you're looking at shareholders agreements, the articles of the company that set out the share structure, as well as bylaws that will inform how you can proceed on a day-to-day basis and dealing with any type of issue that comes up. So when you're looking at what is a unanimous shareholders agreement, I mean, by the name, you know that it does have to be unanimous. All shareholders have to be party to it, and that's all shareholders, whether they're owning voting shares or non-voting shares, if that's relevant to a certain structure. Unanimous shareholders agreements are creatures of statute, insofar as the corporate legislation in most Canadian jurisdictions, and in fact in a lot of international jurisdictions, specifically allow for a shareholders agreement which is unanimous to restrict the powers of directors, in whole or in part, to manage or supervise the management of the business and affairs of the corporation, which is a direct quote from the Canadian Business Corporations Act. So this transfer of power also involves an attendant transfer of liability as well. So to the extent you do have a shareholders agreement and you carve out certain things that the directors are not allowed to do without shareholder approval, it's important to note that that does transfer the liability for those things from the director to the shareholder. Now, there are complications in that regard. For instance, if the shareholders, a simple example, if the shareholders of a company are two holding companies, and you have a shareholders agreement which purports to remove some of the powers of the directors to those shareholders, and those shareholders are corporations as opposed to individuals, and the liability under the corporate statute would suggest that a director has personal liability for forgetting to do X, or not paying statutory payments to the taxing authority or what have you. To the extent that power has been taken away by a shareholders agreement and given to the shareholders, which are themselves corporations, it's one of the few areas where a court will look to pierce the corporate veil and actually go after the underlying individuals who are making the actual decision as opposed to the corporation. So it doesn't act as a full shield from a liability perspective by putting that structure in place, but so it's not that's not a strategy that's employed in this particular case. You can have shareholders agreements which are not unanimous, and they can deal with the intra-shareholder issues. But a shareholder agreement which is not unanimous will not fetter the discretion or powers of a director in a company. So we can generally characterize things in a shareholders agreement as kind of falling into three categories. Elements of a shareholders agreement deals with governance control, any dealings with shares, and there are a fair number of ways that shares can be dealt with and that you want to provide for in a shareholders agreement. Agreements as to additional funding, and then agreements as to how one might resolve a dispute, which John went into some detail as to why these things can be different and why they may cost different, but ultimately end up being the same type of process you go through in order to resolve a dispute. Another common element of these agreements, or elements that should be in these agreements, you want your agreements to bind shareholders, but as I've alluded to, some shareholders of companies can themselves be companies or other entities, limited partnerships, trusts, general partnerships. So you want to make sure that a shareholders agreement not only is drafted so as to bind an individual shareholder, but also you want to make sure that any have parties to the agreement. For instance, if a holding company is a major shareholder of another corporation, you're going to want to bind the principals of said holding company in the shareholders agreement as well, so that there's no inadvertent or indirect change of control that the other shareholders of the corporation wouldn't want at least input on, or the ability to block in some way by exercising other rights with respect to dealing with the shares. You're going to want most shareholders agreements will contain basic representations and warranties by the parties, so each of the shareholders will represent to each other that I own the shares, I'm not encumbering them, that type of basic representation and warranty, which can then, if breached, allow for a cause of action that could dissolve the company or allow someone to buy someone else's shares at a discount. There are all sorts of variations and permutations that you can go through in that way. One of the most important things, before we get into the more specifics and the common elements, that a shareholders agreement should provide for, and this is more relevant for a company that you propose to grow and take in outside money and grow your shareholder base and so forth, as opposed to a company that is two siblings who own a company that plan to help to the business to move to the next generation on a succession basis. Less important in that case is the ability to amend a shareholders agreement. So as we talked about, it's important that a shareholders agreement be characterized as unanimous for a number of reasons under corporate law. But as you get further and further along in a corporation's life cycle and you have more and more shareholders, getting unanimity on any issue gets harder and harder. So typically what you would do is, upon the founding stage of a corporation, set up a shareholders agreement, 2, 3, 4 shareholders at the time perhaps, and provide in that agreement which will be unanimous, that in order to amend said agreement at any later date, you need a requisite approval threshold to be met, which could be 75% of votes attached to shares, or it could be simple majority, or it could be 66% of votes attached to shares, but we also need John Smith to vote because he's the founder and managing mind behind it, and he'll have carved that out for himself so he doesn't get ousted in some way. There are all sorts of combinations, permutations here, but what's important is that you have something other than unanimity that will allow you to move forward if, for example, the most common reason you'd want that is you're at the next stage and you're taking in money from outside third parties. So at a venture capital stage or an angel investor stage, you're wanting to accept money from 6 or 7 different people. You're going to want to be able to deliver to those people who are investing a shareholders agreement that binds and allows them to get the comfort they need on various issues, liquidity down the road, or control issues, or protective provisions, or all of those types of things. And the ability to get that if you have to go back and get everybody's signature on the shareholders agreement to amend versus a requisite approval threshold of some reasonable majority can make a major difference in moving forward and not creating a stalemate at any particular type of time in the life cycle of the corporation. One other thing that is important to deal with in respect of general structure of a shareholders agreement is to deal with if a corporation is part of a corporate group and it itself has subsidiaries, you want a shareholders agreement to deal with the governance of those subsidiaries. You can do that in any number of ways, but I think it's just, you generally need to turn your mind to that issue. It becomes more complicated if said subsidiaries are outside of the same jurisdiction as the top company. So if you have a Japanese subsidiary or a Swiss subsidiary or a subsidiary in the US, you'll have to take note of those corporate laws as to what you are able to govern in respect of those subsidiaries. I've dealt with clients who have subsidiaries in various European jurisdictions where, notwithstanding we own all of the shares of this entity, the board of directors that's appointed to those to govern those subsidiaries have powers that you cannot strip from them in certain contexts. So you have to be cognizant of that as well when you're preparing these types of things. Okay, so from a governance and control perspective, you're really looking at a few things here. It really boils down to who gets to make decisions, on what basis. So you'll want the officers and directors of the company to have the day-to-day right to govern the company. You're not going to want, and having said that, if you are a shareholder of any means, but by that I mean if you own a significant percentage of any corporation, what you're likely going to want is a right to nominate a director. General corporate law would provide that shareholders holding a requisite number of shares can vote the entire slate of directors as a matter of default. So shareholders agreements will typically provide for the rights of certain key shareholders, whether they hold 10%, 20%, 30% of the corporation, to nominate a director, notwithstanding the fact that they wouldn't be able to do so under the default provisions of the relevant corporate statute. So that is very common, especially in a growth stage company that's introducing third-party money. That third-party money almost always comes attached with an obligation to provide for these nomination rights and have it stay at the board of directors level. For smaller participation, you'll at least have someone looking for observer rights. So someone who will get all the same information the board will be getting, but won't have a seat at the table and won't have a vote. The other thing you're looking for typically is, and this is more in the nature of protecting a minority position, but the minority position is, and again, in the venture capital context, is almost always the position that's just put a bunch of money in. So in that context, they can negotiate typically provisions whereby we don't want you to do this, or this without our approval or some threshold approval of the shares we purchase. So founders have common shares. The first level of finance will have Class A preferred shares, for example, and the protective provisions will most of the time be cast as something that you need a certain number of our Class A preferred shareholders in order to do certain things. So those certain things can be make further amendments to the articles, issue new securities of any kind, change the officers and directors, consummate an event that would constitute a sale of the company or a part of the company, redeem shares, conduct any kind of related party transactions. So we want to make sure there's no conflict, or if there is, you kind of need to come to us for approval. Lending or borrowing, spending X amount of dollars on capital expenditures, all of these things that can be subject to a protective provision, and is generally a protective insofar as, absent these provisions, the relative interest in the company from a voting perspective would allow people to push these right through. But so these provisions alter that paradigm and allow someone who has put money in and wants to actively participate in the governance of the company to do so, absent the construct of a typical Corporations Act that's in place in any given province in Canada or elsewhere. shareholders agreement can also provide for all sorts of other things with respect to officers and directors and how compensation might flow to these various parties. This is more relevant typically in a larger business which maybe has 3 or 4 principals and perhaps they're not accepting outside money, so it's a little bit of a different. There's no third party sitting at the table, but there's a need for flexibility as to how someone gets paid. So someone may have a particular desire to receive dividends as their compensation as opposed to a salary, or they may want a combination of both, or they may want to have some other type of distribution that's sent to them in order to maximize, sent to them or at their direction to someone else, to a family trust or to what have you. So shareholders agreements can provide that type of flexibility as well, usually on the basis that, if we all agree that I should make $200,000 a year and one of my other partners in this corporation makes $200,000 a year, we can provide the mechanism, the shareholders agreement, for us to be paid that amount of money, irrespective of its character. So have it come out as a dividend again, have it come out as some other type of distribution. You can put all that type of mechanic in the shareholders agreement as well. So you can see that, and there are lots of other things we'll keep going, but you can see that a shareholders agreement can range from very simple 2-page long agreement to a 100-page long agreement when you're dealing with all sorts of these issues. And it gets more complex, obviously, so you have more shareholders, you have different classes of shares, you have shares that can vote and shares that can't vote, or shares that have multiple voting powers, so on and so forth. So the other thing from a governance perspective is the shareholders agreement can and usually does change what the underlying default in a corporate statute would be, so far as how much notice you need to give for a meeting, either of shareholders or directors, or what a quorum might be for those meetings. Typically, you will increase the quorum numbers from what was contemplated in the corporate statute in most of these cases of a privately held company, to make sure that a meeting won't take place without certain major shareholders being present and so forth, without them at least waiving that requirement. So moving on to dealing with shares, and frankly, the bulk of agreements deal with this issue, mostly because it has to do with 2 things, money, and what ultimately will happen, how you get out, or liquidity provisions of an agreement. And when I say get out, in a VC context, you're looking at third-party investors who have a window that they want to get in or out of these companies too, usually in the nature of 5 to 7 years. So they're always looking to at least put in place the mechanisms by which they can do that. Versus a privately held company that at this point in time, the present intention is that it's 2 or 3 siblings that are running it, and we would like to pass it to our children if they're interested. But at the same time, there's going to need to be some way to address issues such as the death of somebody and some other party not wanting to take the shares over and/or participation in the business. All of these things, well, and the other thing that comes up is I've dealt with this particular situation where the shareholders agreement, the most hotly contested provision in the entire shareholders agreement was a restriction on transfer provision, which it was very broad insofar as, do as much estate planning as you like, and transfer shares to this person, or to maximize how this plays out for you from a financial perspective. But under no circumstances are the shares ever transferred to the hands of your wife. One person in particular was named in the agreement, said, I will not do business or sit at the board table or anything else along with that person. And funny as it sounds, that type of thing can happen and does happen, that there are specific underlying family issues that have to be dealt with in these contexts that will be part of this. If you ask the right questions of someone who's asking you to draft this type of thing, you can drill down on, what's really important to the people as they think forward as to what might happen at some point when they have to get rid of shares or have to deal with a crisis point in the life cycle of the corporation. So permitted transfers, restriction on transfer is typical, that you can't transfer other than, you can't unilaterally decide to transfer unless it's to a permitted set of enumerated entities. So I would be able to transfer my shares to a trust that I control, or a corporation that I control, or a partnership that I'm the general partner of, or to my immediate family members, or any one of those. Those are very typical provisions. The preemptive right provision, or sometimes referred to as the right of first offer, would allow any shareholder, or sometimes certain classes of shareholders. This right's not always given to everybody. Generally, it's sometimes given to only major shareholders, or shareholders over a certain percentage interest in the corporation. Allows them at least maintain or prevent dilution of their position, the relative weighting of their interest in the corporation. And there's usually an ability to take up, if to the extent someone else doesn't participate in the preemptive right, then you can take up any balance that is left on the table. Tag-along rights are what they sound like. If someone purports to sell after having to someone outside of the group, you can participate on the same terms. You have a right to participate on the same terms. If someone comes to one of the principals and says that they would like to buy the business, if you get certain people buying into that, you can drag the rest of the people along and do that. Involuntary share transfers, these occur when, and need to be dealt with in shareholders agreement when someone dies or they become disabled or they want to leave on a voluntary basis or you want to get rid of them for cause. And there are all sorts of mechanisms to deal with how that takes place. Usually life insurance plays a role in this, in picking out somebody who wants to leave or someone who dies or someone who's just disabled. And I've seen that lots of provisions deal with, because money is always an issue in the corporation, dealing with this on a protracted basis. So we'll take 3 years to pay out, what we establish as the value of these shares, based on the valuation being done or based on a multiple in our financial statements or what have you. Other things that are typically found in agreements, a requirement to pro rata fund any capital needs of the corporation, so you can't find outside sources of that. Dispute resolution mechanisms, which we've had adequately covered in other presentations. And as I've alluded to throughout, the context is important. Most of my experience in dealing with these matters is in the venture capital context, so there are a number of issues that arise there. Mostly dealing with, I want to be able to get out at a certain point because I have an obligation to my underlying fund to produce a return, and I want some control along the way, and I want to participate in future rounds. So that all is what happens there. And so these are some of the key issues that you'll find in the materials that you deal with in each of these situations, which perhaps don't fall over into the other contexts where these happen. One of the last things I'll mention in the venture capital context in particular are information rights. This is a large issue that is dealt with fairly extensively, and you're looking at this stage in a company's development, finally auditing your financial statements, for example, providing those to investors on a timely basis, providing quarterly information on an unaudited basis, providing monthly information, providing budgets, all of those things that usually are required in order to properly monitor the investment, but also to report back to the underlying investors in a fund, if it's a venture capital fund that's invested in an underlying company. Key person insurance also usually put in place with respect to the key person who's driving the company and which the company's success is dependent on. The very last thing I'll say, as I'm appearing out of time, is the evolution of shareholders agreements, which is in the title of my presentation. This is mostly based on, again, the venture capital context, and the Canadian shareholders agreement issue is typically, in the past, been dealt with a single agreement that deals with all these issues. The U.S. model is slightly different. They typically operate on these three types of agreements, called a voting agreement, a right of first refusal and co-sale agreement, and an investor rights agreement, which essentially contains all of the information that we would typically have in a single shareholders agreement. A lot of Canadian companies are moving to this model simply because it then positions them to look familiar to any type of U.S. investor who's interested in investing in the company. So more and more we're seeing Canadian companies shoehorning themselves into these types of agreements, which aren't in any way materially different as to what they substantively deal with. The only difference is the voting agreement and the ROFR agreement are typically unanimous shareholders agreements, as we described earlier, is relevant. The investor rights agreement is typically not, because it doesn't need to be. It's usually only dealing with obligations that the company is putting on itself to give to the shareholders, so information, registration rights, a preemptive right, etc., which doesn't need a buy-in from all the other shareholders in order to make it operative. And I think on that note, we'll leave it at that. If there's any questions for myself or anyone else on the panel, we can field them now.
So just to comment, in terms of volatile share agreements and volatile stock price, and having made the Globe and Mail a number of times, do you guys ever look at dry shifts?
Sorry, I wrote that.
dry ships. It was a public business sustaining corporation. It was in the paper for a period of time because the number of times they reissued their capital, changed their shareholders agreement. The stock was incredibly volatile, very illiquid, and notorious. Look it up on the internet here in the last sort of 6 months, dry ships.
I hadn't read the story, so I will look it up. I think that the one thing that I will say, again, on the evolution theme is that certainly to drafting shareholders agreements, like any other agreement, is reactive to what happens in the markets and or with companies that find themselves in situations that are not previously addressed. And I find that we have a precedent for something, and we used it 6 months ago, and now we looked at it again, and something has always changed that we need to incrementally deal with, because on the back end, we've been dealing with the disputes of some nature which no one thought to address at the front end, so now we're addressing it at the front end, and it sounds like a situation.
Especially if it's multinational.
Absolutely, yeah. So that just adds all sorts of complicating factors to dealing with operations worldwide.
Last question.
When you were talking about the sprinkling and that, it might be an idea for students to register, even though they don't have to, for HST and invoice the company small amounts, and that would set up something that's a little bit of processing, but might be able to demonstrate that they were actually doing something. I was consulting with the company, here's my invoice, etc.
Evidence always helps if you can document something, but there has to be real service behind it to generate the
Be hard to prove.
These rules on sprinkling, when you think about how is a business person going to keep track of all these things, document them, and how's an auditor coming in going to enforce these rules? Very, very difficult. Okay, so on that happy note, thank you all for attending for our webinar. Thank you for listening to us. We're very interested in getting your feedback. Give us some suggestions for future presentations, and we will see you at the next seminar. Thank you.